And so the position that was expressed by the president in his address at the sword cutting ceremony of the new law school premises was actually one that was anchored or hinged on a decision of the High Court in Kumasi. And how the decision here, just for the benefit of our readers, viewers, so see, I think Rivers, the Attorney General, the Regional Minister, the District Chief Executive, and Chuma Punua District Assembly. A decision rendered on 14 June 2018. And if I may quote from page 62 onwards, it says, in his book, Essentials of the Ghana Law of Evidence, the learned author, S.A. Brobe, that's the Supreme Court, as it then was, stated as follows with regards to public policy and illegality. No individual is permitted to use the law to perpetrate the commission of a crime. In civil cases, the rule is that a person cannot found an action by an illegal act, commission, or conduct. And this is encapsulated in the Latin maxim, est tepi causa non oritur actio, or ex dolo non oritur actio. End of quote. That goes ahead to also quote at page 66. In the instant case, reported leases based upon which the applicant was sending the equipment were all null and void and conferred no rights on the applicant. Therefore, the activity which the equipment were being carried out and performed was nothing but an illegal activity. It therefore stands to reason that if the equipment were found in the Chuma Punua District Assembly illegally and were going to be used for illegal mining, then the respondent, by seizing and detaining them, breached no rights of the applicant, which required the court to grant him any remedy. The conclusion is quite instructive. The conclusion is from page 68-69. It says, from the foregoing discussions of the law and the facts of the case vis-a-vis the various legal submissions, the court is of the opinion that the acquisition of the mining leases by the applicant breached statutory or constitutional infractions, which made the purported execution of the mining lease or a nullity. Hence, the applicant had no mineral rights as expected by Section 9 of Act 703. So it is safe to say that the equipment were going to be used for an illegal mining, known in our local parlance as galamsey. As such, the seizure and detention of the trucks and the equipment were justified. This is a decision of the High Court, Kumasi. And this issue was actually tested in the Supreme Court. The lawyers in that case were Osafo Babin and Ejuji Tamaklu. They lost. I was the counsel for the state in that matter. And so, if you had the Supreme Court, the application for tutorial was also dismissed. So, as far as I'm concerned, this issue of the High Court Kumasi has not been challenged. The same was appealed by the Supreme Court after an application for tutorial had been dismissed. So, what is the illegality about the exercise?
But this is a court of...
And I'm yet to know of any decision to the contrary by another High Court or any court at all in the country on the same matter as galamsey.
Yeah, but a court of competent jurisdiction has held, as you rightly say, that no rights can accrue out of an illegality.
Yes.
In this case, the military officers are on the ground making unilateral decisions as to this mining equipment has been used for an illegality and therefore banning it. That isn't what the court has done here.
So the same case, the facts leading to...
Had been seized before you went to court.
Precisely. The equipment had been seized for over 1 year at the police station in Kumasi. The plaintiff in this matter contended that the seizure was unlawful since it amounted to determination, as you said, by the disassembly unilaterally, in fact, by the regional minister unilaterally. And that it also amounted to a violation of their right of a hearing and that kind of thing. So those contentions were made, and this was a ruling. The ruling was to declare that no illegality can give rise to any right.
But that's not the distinction between seizure and destruction.
Oh, so you're now thinking about the severity of the action. Yeah. So the point is that either way, it is punitive. Punitive in the sense that your equipment had been seized and detained for God knows how long. You have been deprived of the use of it. They were claiming as much as about 12 million, total of 12 million Ghana cedis, and that claim was dismissed. That is so different from the ban of the equipment. It's a principle that ought to be underscored. The principle that no right whatsoever can be conferred on a person who is engaged in illegal or criminal activity. And that, for me, is the most significant point. I think that, yes, I recognize that it may seem harsh to you, and that's why people are complaining, but it may seem harsh to you. What about the far-reaching, devastating effect on the nation? there's an activity that has resulted in pollution of our water bodies, massive destruction of various towns and all. It has actually even weakened the foundations of certain towns. And these are acts that have generational effect. So it has effects even beyond our generation. I think that the monumental damage that is being caused ought not to be, or side ought not to be loss of that. And that is, for me, that is what is most important. And I find it, with all respect, a little bit reprehensible when people, instead of rather ensuring that the government leaves no stone unturned in its efforts to bring to a halt this menace, rather are advocating for recognition of some non-existent rights of persons engaged in the
But
acts.
if you ban the excavators, in the Eston Kibu case, you seize, and so the evidence was still there. If you ban it, what's the evidence to prosecute?
The evidence is there because we first and foremost visits to the scene were conducted, pictures were taken, pieces of the equipment were also taken, even the fact that the equipment were in water bodies. All there, the evidence was there. So there clearly has not been an undermining of our effort to prosecute the case effectively. And that leads me on to the issue that you said that, yes, people
The
are
prosecution?
not being, yes,
I'll come to the prosecution, but there's a quick one that just occurred to me. The law that the opponents to this banning had cited is that the process is you seize, give the police custody, eventually the minister can repurpose. In the Eston Kibu case, you appear to have complied because you seized.
No, we just seized the equipment.
Yeah, but that's what the law says you should do.
Yeah, but
in this
no,
case,
see,
the law, you've actually bent the equipment, which is contrary to what the law says.
No, what we have done is to decommission the equipment, decommission them in a
You're
way.
setting fire to it.
Yes, but I'm saying
to
that, yes, so it still does not divest us of the decision to deal in a manner as
But
appropriate.
that's not what the letter of the law prescribes.
No, but I'm saying, no, that letter of the law is for prosecution. The provisions are for prosecution and what ought to be done consequent upon prosecution. So if you want to prosecute the matter, we cannot prosecute in any other manner at all. But I'm saying that let any person also refer us to an authority which contradicts decision in Eston Kibu, where the principle is stated that no illegality can confer on any person any right whatsoever in the country. And that's it.